Effect of Article 5 in NATO Treaty in case of Russian nuclear strike on United States. Article 5 of the NATO Treaty serves as a collective defense clause. It stipulates that an armed attack on any of the NATO members shall be considered to be an attack on all, and consequently, collective action should be taken in response. This means that if Russia launches a nuclear strike on the United States, it would trigger an obligation on all NATO members, including the European nations, to come to the aid of the United States. Such an obligation could be huge, given the destructive nature of nuclear weapons. However, in practice, it is not exactly clear what collectively coming to the aid of the United States would entail. Firstly, Article 5 does not specify whether that help would be military action. A multinational force could be established to conduct military action, but it may well be that the NATO allies actually provide logistical help and support only. Secondly, there could be legal arguments between the NATO member states about whether military action itself is justified. The treaty does not provide a definition of an armed attack, and it could be that some NATO members argue that the United States has itself carried out an armed attack and that there is no right to collective self-defense. However, the practical reality is that in the event of a nuclear strike from Russia, the likely and most feasible option for the NATO allies to give effect to Article 5 would be military action. The obligations triggered by that article could have long-lasting and profound significance for the international community, and there could be severe consequences from a geopolitical perspective. For instance, if the NATO allies adopted a military option under Article 5, but the military operation as a whole was deemed to have been a failure, that could well be the end of the NATO alliance. However, it should be noted that the United States has indeed used military action under Article 5 of the NATO Treaty after the 9/11 terrorist attacks in the New York Twin Towers. The view taken by the United States and accepted by the other NATO member states was that the attacks constituted an armed attack, and NATO subsequently launched Operation Enduring Freedom to remove the Taliban regime in Afghanistan. This historical precedent underscores the meaningfulness and relevance of the obligations derived from Article 5. However, it is submitted that the military operation against the Taliban is not the most definitive interpretation of armed attack under Article 5, because terrorist attacks are different from conventional warfare, and an issue may arise over the application of the Collective Defense Clause in the context of terrorism. The application of Article 5. When the independence, security, or territorial integrity of any of the parties is threatened, and applying Article 5, the process requires just two levels of decision. First, the threatened party has to notify the Council at once of the existence of the danger, and subsequently each party agrees that it will afford the armed protection and will take such action as it deems necessary, including the employment of armed force, to restore and maintain the security of the North Atlantic area. Such treaty provisions are not unusual in collective defense treaties such as the NATO Treaty. However, the novelty in this case lies with the question of how the request for activation of Article 5 stage specifically would be exploited in the case of a sudden and massive nuclear strike on a NATO member state, including the United States. The legal purity of acting within a non-attaché military chain of orders and the proviso that a wide scope of military measures is entitled under international law are often debated. Because of the process of decision in activating Article 5 allows for the threatened friend to be the starting trigger of the collective defense measures to critics because of the political decision made in the light of nuclear toleration. The feared danger of nuclear start is no hesitation a phenomenon of absolute self-defense. In the light of the fact of Article 51 of the United Nations Charter provides that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack leaves the member of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security. Collective defense treaties such as the NATO Treaty, and particularly the provisions in Article 5, may not yet empower the member states to determine the specific act of self-defense. The prior juridical inquiry into the words and matters of the article reason that only a full-scale armed attack from the outside will come under the compass of Article 5. This is seen in the works of our Paris military action under the NATO Treaty and in international law, which provides an extended juridical inquiry into the operative terms of the article. Such work highlights that the terms of armed attack and measures necessary are not yet paved with clear and open materials to the lawyers who seek for distinct and simple interpretation, and thus it is a controversy showing the availability and practicality of alternative readings. It is that kind of lawful arguments that may be presented by political and juridical consultants, but the most primary reason for analysis is what actually the essential precondition of Article 5 seen, and therefore the discovery of limiting checkpoints to the collective defense capabilities. Any interpretation of the provision should bear in mind the maximum is that if non-military measures are applicable, no force may be resorted to, and that the rights of a state state party cannot be influenced. Activating Article 5 in case of a nuclear strike. In the event of a nuclear strike on a NATO member state, Article 5 would be triggered. The process for activating Article 5 in the event of a nuclear strike is set out in the NATO handbook. The decision to invoke Article 5 is a political decision, and only the North Atlantic Council can make such a determination by a unanimous vote. The North Atlantic Council is the principal political decision-making body within NATO and consists of representatives from every member country at the level of ambassador. However, in the event of an armed attack, any member of NATO can immediately request consultations under Article 4. Such a request triggers an emergency meeting of the North Atlantic Council. The member state would be expected to present a case as to why they believe they have been subjected to an armed attack. If there is consensus among the member states that an armed attack has occurred, then the collective defense provisions under Article 5 can be triggered. In such a situation, all available evidence, including the nature and intensity of the attack, will need to be submitted by the member state to help the North Atlantic Council to reach a determination. This is known as the evidence of the case process and is outlined in the NATO handbook. Any member state which is subject to an attack has an inherent right of self-defense, including the use of force to defend itself, in this case, a nuclear strike. This raises the critical question of whether the attacked member state must wait for the collective defense provisions of Article 5 to be invoked, which may involve an evidential and decision-making process, or whether that state can act immediately in self-defense. The International Court of Justice has observed that the existence of such a right cannot accept as a justification for its exercise. In context of this discussion, the ICJ suggested that a right to anticipatory self-defense could not be invoked as a justification for taking action when using force to respond to an actual or imminent armed attack. However, there is the added complexity of a nuclear strike, as there may be very little time in which a threatened state could take defensive action. This is a question which is still the subject of legal and academic debate in the context of the Charter of the United Nations and customary international law. The International Court of Justice has observed that the existence of such a right cannot accept as a justification for its exercise. In context of this discussion, the ICJ suggested that a right to anticipatory self-defense could not be invoked as a justification for taking action when using force to respond to an actual or imminent armed attack. However, there is the added complexity of a nuclear strike, as there may be very little time in which a threatened state could take defensive action. This is a question which is still the subject of legal and academic debate in the context of the Charter of the United Nations and customary international law. Response from NATO allies. The response of NATO allies would be likely governed by the North Atlantic Council, the main political decision-making body within NATO in the event of activation of Article 5. The Council operates on the basis of unanimity, so all member states would need to be in agreement. If the Council determines that a qualifying attack has occurred, each member by the terms of Article 5 would then have their own right to act in their self-defense both individually and collectively, including full military response. However, it is also open to each member to decide what level of assistance and support to give. This means that the actual real-life response by NATO allies could vary depending on the nature of the particular nuclear strike and each member's interpretation, as well as political and strategic relationships between member states. Furthermore, it is necessary to consider the proportionality of military actions. As highlighted by the European experts, the Charter of the United Nations in principle requires that the response to such an attack by NATO should also be carried out in close coordination and consultation with the United Nations Security Council. Any NATO decision to take military action under Article 5 would need to satisfy the formal treaty principles of necessity and proportionality. Such actions should be no more than required and with reasonable efforts to use peaceful means.